Good morning, everyone. Come on. I know it's early on a Friday. Good morning. You're here for a purpose and a reason, right? You want to learn more about intellectual property, what it is, and how it affects you. As small inventors, entrepreneurs, makers, business people, you want to make sure that your business, your brand, your invention, everything that you have put your heart and soul into is protected, correct? So that's why you're here. And this morning, I'm going to give you a brief overview of intellectual property, the four main areas that go into it. Now, this is not, by any stretch of the imagination, a deep, in-depth, involved conversation. I only have like 45 minutes. If you have questions because you need to understand something, please ask that question. But be aware that because I only have 45 minutes to cover four major topics, I might have to save it to the end, okay? My name is Gwendolyn Blackwell. Please feel free to call me Gwen. I'm a supervisory patent examiner here at the office. My bio is in the booklet. I've been doing this IP thing for approximately 20 years now, okay? So in order to understand intellectual property, which I'll be calling IP, you need to realize that it's made up of trademarks, copyrights, trade secrets, and patents. Now, when it comes to patents, there are three subcategories of patents, and I'll get into those further into the presentation. There are utility patents, design patents, and plant patents. Yes, sir. Nathania, will the slides be available?
My voice isn't that loud. Yes, we will make the slides available to you. We will be posting them. We will update the InventionCon webpage, and we will post USPTO approved slides. Now, you will have slide presentations for external speakers. Those slides won't be made available, but our USPTO approved slides will be made available.
Thank you, Nathania. For utility and plant patents, your protection goes 20 years from date of filing. Design patents are a little bit different. They're 15 years from date of issuance. That's the protection that you would have if you're able to obtain a patent in one of those areas. When it comes to copyrights, copyrights are generally the life of the inventor plus 70 years. There are some circumstances where the protection is longer, but that's more of a usually for those that are small business owners, entrepreneurs, it's usually 70 years plus life in the inventor. Life in the inventor plus 70 years. Trade secrets, as long as you can keep a secret, you're protected, right? And then with trademarks, it comes down to as long as the mark is in continuous use. So we're going to start off with trademarks. And when you start with trademarks, Mary gave a great overview of what trademarks are. You're supposed to be able to look at a trademark and recognize the source of goods or the service that's associated there too. So when you're thinking about your branding, if you haven't already done your trademark, that's kind of like how you want to think about it. What is my mark conveying about my service or good? Is anybody that looks at it going to recognize that when they see this mark, it's my product or it's my service? And while you don't have to register your trademark, we really encourage that you do so, because it gives you the right to enforce nationally and bring legal action into federal courts if someone tries to use your mark, okay? You're able to use the federal trademark registration symbol, which is the R with the little circle. You can register your mark with customs, which is awesome. How many are familiar with Canal Street in New York? So what happens on Canal Street? For those that know, somebody will come up to you and say, hey, fake bags, yes. Would you like a Coach? Would you like a Prada? Would you like such and such? And they take you somewhere. And they say, okay, well, what type of bag do you want? And they'll pull out this symbol from a little piece of plastic and slap it on. Okay, so how do I know? Yeah, I saw it, but I didn't buy. Because that's counterfeit goods, right? So they're cracking down on this. New York has been heavy on cracking down in other ports to keep people's trademarked goods from being counterfeited. When you register, you help them do that. It also serves as a basis for foreign filing if you want to register your trademark in any other country. And it is published in the US trademark database, which puts people on notice that that mark is in use. So trademarks can be words, such as Starbucks, can be designs. Everybody knows. I'm still trying to figure out, is that a mermaid or a lady holding fish? But everybody knows when they see that, that means you're talking about Starbucks. Can anybody think of any other like popular designs? Target, yes. Nike, the swoosh, right? Target, and the bullet sign. One of the things also about trademarks you need to recognize, trademarks can also be colors. Now, ladies, if you were to receive a Robin Blue Egg box, colored box, would you be happy? And why is that? Tiffany's. Gentlemen, are you paying attention? They can also be smells. How many of you remember those plastic shoes from the 80s? Jellies. It might have been a jelly, it might not have been. But some of them had a scent to it. That scent, that bubblegum scent, was associated with a particular brand of those plastic shoes that all little girls wanted. I'll raise my hand. I wanted them too, but my parents said no, they make your feet sweaty and stinky, so we're not buying them. But there was a smell associated with one of those brands, and that was trademark. So think outside the box. Don't think necessarily it has to be necessarily a word or design. It could also be representative by a color or a smell. Are any questions on trademarks? Okay. When it comes to copyrights, copyrights protect original works of authorship, including literary, dramatic, musical, artistic, and other works fixed in a tangible medium. The thing you need to remember is it needs to be fixed in a tangible medium. Now, are copyrights examined here at the Patent Office, Patent and Trademark Office? No. Oh, say, look at the slides, look at the slides. It's at the Library of Congress. That's where copyrights are administered with their registration. The USPTO advises the executive branch on IP issues, including copyright, but the copyrights are not taken care of here. That's at the Library of Congress. Realize that as soon as you put something in a tangible medium, when you wrote it, you drew it, you're an artist, you're a sculptor, it's automatically copywritten, okay? You can use the little C symbol on your works. So you're like, well, why should I register it? You should always register your copyright registration, which compared to a trademark and a patent is inexpensive, seriously inexpensive, because it helps you to better protect your copyright, okay? Here are some examples of things that can be copywritten. And I'm gonna give an example of why you'd wanna register, all right? How many are familiar with Marvin Gaye? I remember when he passed, my mom made me play his records all day long. Yes, I said records. And you're like, well, that's not, for those that don't deal with record players. Yes, I had to be the one to flip it from side A to side B and make sure that the needle didn't scratch something up when he passed away. Marvin Gaye's been gone for over 30 years. However, there have been several court cases due to copyright infringement from other musical artists that his estate has brought against them, and they have won. So when you look at that life plus 70 years, you may think, oh, that's not much of anything, but think about the millions that his estate is getting in fees due to that infringement. So if you have something that you think is valuable, well, anything you do and create is valuable, correct? Because it's yours. Make sure that you protect it, because it's not only for you, but your future generations may be able to make sure that they get something from that as well. Any questions so far? How am I doing on time? Good. Yes, sir. No, sir. The question was, can you make a copyright of your patent? Patent is a separate area of intellectual property. As soon as your patent is published, it's out there. So it's a different type of protection when it comes to somebody being able to copy a patent. That's a different area of infringement. It has its rights in and by itself, separate from a copyright. Okay. Yes.
If you can wait for the microphone, please.
I've had several clients ask me about this situation of having to market before they have copyrights. And I'm wondering, was that a previous law, or is that just an old wives' tale that you had to do the circle and see before you gave notice?
You don't necessarily have to do the circle and the C. Think about it. When I had indicated how a copyright is created, as soon as you put it in a tangible medium, it's copywritten, whether you have the C or not. Now, the C for many people are like, oh, this is a copyright. But anything that you find on the net, or, you know, if you're doing YouTube or something along those lines, that's automatically copywritten. You shouldn't necessarily go and use it without permission, correct? People don't think about that, huh? It's like, oh, it's out in the World Wide Web. I'm free to use it. No, not necessarily. You're not.
We have another question over here.
Yes.
Good morning.
Good morning.
Copyrights just can be enforced within the United States or anywhere?
They're enforced here in the United States.
Okay, so if somebody's copied your work outside the United States and use it outside the United States, you cannot basically go after them.
I'd have to look that up because I'm not an expert in the copyright area. Unfortunately, I'm just patents. But I can look. I'll look that answer up and see if I can help you out a little bit later.
And we do have a booth outside for copyrights. If you have a specific copyright question, they can assist you with that as well.
Okay. Are there? Yes, ma'am. We have a question down here.
Good morning. I had a question about patents. Can you choose how long an item can be on, and you might have already answered this. I thought some patents could last for 5 years and some could last for an extended period of time. What is that decision?
The protection for a utility and a plant patents are from 20 years from date of filing. So whatever your filing date is, you get 20 years from that date if your application issues into a patent. For design patents, it's 15 years from date of issuance. And so that's on our first slide, and that should be in the slide deck that will be available later online, so you can have a visual for that. Okay. Are there any other questions? Okay, let's come to one of my favorite parts, trade secrets. Trade secrets is any information that derives economic value from not being generally known or ascertainable. So what's the thing about trade secrets? They're secret, right, to your business. It can be formulas, patterns, compilations, programs, devices, methods, techniques, or processes. So one of my favorite trade secrets is Krispy Kreme. I love Krispy Kreme donuts, especially when the hot sign is on. And if you've never had a hot Krispy Kreme donut, I'm sorry, please immediately find one nearby and have one. Do you know they now post online when the hot sign is going to be on? So you don't have to sit around waiting like years past. You can just go grab one and roll away. But yes, I prefer Krispy Kreme over Dunkin' Donuts. Now, the Krispy Kreme recipe is a trade secret. Can you think of any other trade secrets? Coca-Cola is the most famous one, right? KFC. Not anymore? It's not out. People might want you to think it's out. But no, Coke has kept that formula around for years, decades, over a century. You know, they took the Coke out of it, but the rest of the recipe is basically the same, you know? And there's been a lot of people that have tried to copy it. Think about it. That's how we have Pepsi. That's how we have RC. That's how we have all those generic off-brand colas that you can get easily at the dollar store. But the Coke recipe is what it is. The protection stems from common law from the 1800s. And all states have some sort of trade secret protection, and most of the laws are based upon the Uniform Trade Secrets Act. One of the great things that happened was in May of 2016, it was signed into law, the Defend Trade Secrets Act. And what it did is it allowed those who felt like their trade secret had been improperly attained to have a federal course of action so they could go into federal court to bring their case. Okay? So how are they useful? It's a way of doing something better than somebody else, or how you feel is better than somebody else, and keeping it a secret. And you don't have to disclose it. It can also give you a competitive advantage with regards to customer lists, product formulations, and search algorithms. Did y'all know that the search algorithm for Google is a trade secret? Right? You don't think about that, right? I mean, how many times have you heard, go Google that? Do you hear go Bing that? Go Safari it? Hit that Internet Explorer and try it that way. No, it's very important because Google has some really, really good searches, correct? And actually, the way that they protected it is those that created it, it was part of their graduate program. So in order for them not to disclose it, they kind of dropped out. So if y'all are in graduate programs, I'm not saying drop out, but I'm saying sometimes that's what people do in order to protect their trade secret because they feel it has that much value, okay? And because trade secrets are a secret, there's really no set term for protection so long as you do what? Protect your secret. So you wonder, how can you lose the trade secret if you're doing everything that you can protect your secret? And sometimes it comes to failure to take adequate steps to prevent disclosure. So if you have a secret recipe that everybody is saying, oh my goodness, this is so good, are you just going to leave that recipe sitting out for anybody to find it, or are you going to lock it up somewhere? Are you going to talk about your business, your secret business plans, or what you consider a trade secret to your company in a public place? Are you going to talk about it without having a non-disclosure act in place if you're trying to shop your business? The answer to all that is no. You're going to do everything that you can to protect it. And if you must talk about something in order to get some type of funding or financing, then make sure you protect yourself with a very strong NDA. Okay? So another way to lose it is an owner or owner-authorized disclosure. So if you don't protect it with a non-disclosure agreement and then you just go talk about it, well, you just lost your trade secret, right? If someone reverse engineered it, they bought your product or they try to figure it out what was going on, well, that's a way to lose your trade secret. Or independent development. Somebody comes up with your idea product, your secret, independent of you. That's another way to lose it. Now, the first two are things that you can control. The second two, not necessarily. So you kind of leverage. Do I want to keep this a secret or see if I can get some protection under other areas of intellectual property? Any other questions so far? Now we come down to the good stuff. So what is a patent? A patent is the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. It is for a limited term, as I had discussed before. It's territorial. Protection is only in the territory for which is granted. There is no such thing as a worldwide patent. In the Americas, the United States is bordered by Canada on the north and Mexico on the south, right? I did a detail in Detroit, and from my office window, Canada was right across the river from the Detroit River, from where our office was located. And so it was a simple bridge ride to get into Canada. And some people will believe that, oh, well, I find my application, I live in Michigan, I live in Detroit, I live right there, I see Canada every day. And they file an application and they'll be like, oh, well, I got protection there because it's right there, right? I can see it. This is all the Americas. No. If you get a patent in the United States, the patent is only good in the United States. If you want protection in Canada, you have to file in Canada. Mexico, you have to file in Mexico. Please remember, there is no such thing as a worldwide patent. If somebody comes up to you and tells you, I can get you protection all over the world, run, don't walk. Because there is no such thing, okay? Yes, sir.
What is a WO patent?
A WO is a WIPO, World Intellectual Property Organization, and a WO document is not a patent. What it is it's a patent application publication. So it's put out there about 18 months or so after filing. What WIPO is, and this is kind of going in the weeds a little bit, so I have to give a very high overview. There is a method through the Patent Cooperation Treaty, PCT, as administered by WIPO, that allows one to take their patent application, go through this process under the Patent Cooperation Treaty, and get their application into a format that they can then take that one application and file it in those countries that are signed on to the Patent Cooperation Treaty. Once you file in those other countries for the national stage, that's when your application will be examined. What WIPO does is for those applications that are filed under PCT, it kind of gives you a preview of what you may or may not see when you do choose to file it in one of those member countries. So it's not a patent that will give you the rights to exclude others from making, using, or selling your invention. It is a more formalized route to take your application and to more easily file it in other countries. The WO document is just a publication of an application, but it's not a patent itself. Does that help? We can talk some more after if you have any more questions, okay? Okay. So the government grants the property right in exchange for disclosure of the invention. It's like a quid pro quo. In the United States, we will give you this amount of time to have exclusive rights to your invention, to keep others from making, using, selling, or importing it. And in return, you're going to give us a nice little detailed way of how to make your product, or what it's made of, or how to use it, however you claim your invention. In the United States, a patent is a property right granted by the government to an inventor. As I indicated earlier, it gives you the right to exclude others from making, using, selling, offering for sale your invention throughout the United States, or importing something that could be your invention counterfeit-wise, kind of like when I was talking about branding and trademarks, into the United States for a limited time, and then you have to tell us how you did it. There are 3 types of patents. There's the utility patent, which is a new and useful process, machine, article of manufacture, or composition of matter, or any useful improvement thereof. So when we're talking about a utility patent, we're talking about, let's suppose, the chairs that you're sitting in, how to make those chairs, the materials that go into those chairs. Those would be utility patents. A design patent, on the other hand, goes to how something looks. So again, using the example of your chair, it's not how it's made or what goes into it, it's how it looks. So it goes to the design. It's an ornamental type of patent. And then a plant patent is whoever invents or discovers and asexually produces any distinct and new variety of plant. Many may think, oh, well, this is like just flowers, along those lines, but it's actually deeper than that. How many of y'all like potatoes? I like mashed potatoes, fried potatoes, sliced potatoes. I mean, I'm sorry, I'm having a moment here with potatoes because I like potatoes a lot. But if anybody knows, potatoes are root vegetables, correct? And they can be very, very sensitive to ground temperatures. So if there was a potato brand that was invented asexually that it wasn't as sensitive to ground temperatures, that could potentially be a plant patent. Okay? Any other questions so far? Yes, sir. We have a question over here.
Hi, good morning. You define the patent as something that is the right to exclude others. And the problem for single inventors is that to discover or how to dissuade others from for enforcing this, because we have no method of enforcing our inventions, our patents upon somebody who illegally uses it. It's only done when you discover that somebody else is using it. Does the patent office play any role in the enforcement of this?
Unfortunately, the Patent Office does not deal with enforcement. We're only with the prosecution, meaning we'll grant you a patent, but once the patent is granted, we have nothing else to do with that patent process. We do not go into enforcement. I highly suggest that if you find yourself in that situation, that you discuss that with a good patent attorney that may be able to help you or tell you which way you need to go in order to hopefully get the other person from stop using your product. You're welcome. I'm sorry, there's a question here and then a question there.
I know about the patent part of no enforcement from the USPTO, but we've all been to the movies and see the warning that if you copy a movie
Yes,
or
sir.
a book, the FBI knocks on your door. Just for everyone else here, and I'm not sure myself, but when you say that the Patent Office doesn't enforce a patent, but when it comes to copyright and there's that warning of a big fine or prosecution by the FBI, so we have 3 ways for a product. So trademark and copyright can be, you can go through, or the FBI gets involved, but not a patent. I just want to be clear, there's no warning on a patent that if you copy this, the FBI is going to knock on your door. But a copyright or a trademark infringement, is that a little different when it comes to enforcement?
The Patent and Trademark Office and the Library of Congress. Hello. The United States Patent and Trademark Office, as well as the Library of Congress, were not in the jobs of enforcement. The notice that you see at the movies that you're talking about with the FBI, that notice is a notice that they're just putting out there. You know that if you copy somebody's patent, they can come after you. If you copy your copyright, they can come after you. Your trademark, they can come after you. It just comes to how certain industries want to put their notice out to say, if you copy this, the FBI is coming for you. We have nothing to do with that. FBI is a completely separate department of the government, and we don't coordinate with them to enforce anybody's rights with regards to their intellectual property. That is completely on the owner of the intellectual property. Oh, okay. Yes. I'm not completely sure how that enforcement side works because we don't necessarily deal with that. With regards to trademarks and patents, it puts the notice out there to stop the counterfeits at the border. So with regards to customs, they do have a list and they do try to make sure that counterfeit goods are not allowed to come into the country. But with any intellectual property you have, you need to be kind of like diligent in making sure that you're aware of what's in the marketplace or what's going on. And if you do see someone that looks like they're copying your intellectual property, to put them on notice as soon as possible. And then to get whatever agencies involved, if there is an agency that could be involved, whether you're doing it through an attorney, whether you're in the court system or what have you. Okay, yes.
Thank you. According to the current law, the intellectual property is granted for the first to file, but not necessarily to the first to invent. So there's a big debate going out there that this is working against the garage inventor and it give advantage to the big corporations. So I myself do not understand this. So can you give us some comments and your view on it?
You would give me that good question this early in the morning, right? Again, when it comes to enforcement, you need to be diligent. The question about first to file versus first to invent can be an issue. That's just being completely honest. It can be an issue. If you find yourself in that situation, there are mechanisms here at the office that you can use. On my side of where I am in prosecution, that's not something that we necessarily deal with when it comes to whether someone was the first to invent it or they, somebody else beat them to the office. But there is something that you can do. I will have to talk to you a little bit later about that because I can't remember completely the mechanism offhand. Oh, okay. Is that okay, sir? Okay. And I have about 8 minutes and a few more slides to go.
Going back to your discussion regarding design patents, can you tell us a little bit the difference between design patents versus trade dress, and when is it appropriate to go with which route?
What do you mean by trade? I'm not familiar with trade dress. So,
my understanding is that trade dress is similar to design. It's kind of like a restaurant, and it has an outline of like a certain colors and looks, right? So that is the type of design, but it's I don't know. That's why I was asking the question because I understand there's an overlap, but when is it appropriate to go with one or the other?
I'm not familiar with trade dress. Don't deal with that too often. I will say that when it comes to the design patents, that's when you take your design of whatever your product is, you submit an application to the office, and they do a search. The design examiners do a search to determine whether the design that you have is out there, whether your design is novel and non-obvious. If it's found that that's the case, then they'll grant you a patent and you'll have exclusive use of your design for about 15 years from date of filing. For example, who remembers the spinners on wheels? The basketball player, Sprewell? He had a lot of different design patents just on different patterns on the hubcaps, And so he marketed that, sold it, made a lot of money, but that protection's only good for a particular amount of time. I'd have to go a little deeper into research about the trade dress to be able to give you the difference between the two. If you want to talk afterwards, we can do that as well. Yes.
With the shape, like there are cookies that's shaped like a peanut, and that design for that cookie, that shape of that cookie can be trade dress. So you want to,
Kind of like a trademark for a shape.
Yeah, so different elements of it so that people can readily identify a cookie at a distance at a certain shape.
The Nutter Butter cookies.
That's what I'm talking about, that.
So if you saw that saw that peanut shaped cookie, you know that's a Nutter Butter, or it should be a Nutter Butter. So with that definition, it comes to that it's kind of like a trademark type thing, that as long as you're using it, somebody else can't come in. So there's a difference. Whether or not someone should do a trade dress versus a design patent, or do a utility versus a design or what have you, it all comes down to what is it you're trying to protect and how long you want to have that protection. You know, do you think that this is only going to be something that's good for a short amount of time? Or do you think this is something that could endure much longer than the 15 or 20 years that you may get from the patent office? So that's the way that you have to kind of look at it when you're thinking about your IP portfolio for your business. What is the best method of using intellectual property to protect my different levels of my business? Yes.
Yeah, a famous example is the Coca-Cola bottle, which we all recognize as a trademark. You see that shape and you know that it's Coke. But if you go all the way back to the beginning, it was registered as a design patent, so it expired. So technically, somebody could take that shape and use it to sell something that is decidedly not similar to Coca-Cola, and the Coca-Cola company, in principle, should not be allowed to stop them. But what did they do? They morphed it from, they said, oh, well, now this is so recognizable, we claim it as our trademark. Therefore, we can keep using it in perpetuity to associate in the mind of consumers our brand as a source of liquid refreshment and world peace, right? And Santa Claus and everything good in the world. With that shape, even though originally it was a design patent, I believe.
Yes,
and so, you know, you might say, well, is it this or is it that? The ultimate answer is ideally it's all of the above and to the fullest extent possible.
Thank you so much. I only have a few more minutes to get through the rest of the slides, so if you have any questions, please hold them until the end, and I will be available to answer any questions that I can. So in the role of the patent system, it's used to protect inventions, encourage innovation, promote commercialization, and the application of the invention. Basically, when you put your patent out your invention out to the world and it gets patented, someone's going to look at it and say, I could do that better. I mean, I'm just being honest. You will get your exclusivity. It will take them time in order to improve or what have you, but it encourages innovation. Think about it. How many times have you seen something and you're like, I could do that better. I could make it faster. I could make it smaller. And then you're like, oh, there's a patent on it. Let me go look at the patent. Okay, this is the process of making it, or these are the materials. I can use biodegradable materials that's gonna be cheaper, and you know, the overall net effect will be cheaper. That's what patents do. They help to encourage innovation and commercialization. So why should you get one? It will help you gain entry into and deter others from entering a particular market. Patents are like property. You can use it to attract inventors. It can be used as a marketing tool. How many times have you seen patent pending? Or we have a patented invention. When you hear that, you think, oh, well, if they have a patented invention, that's something that's not necessarily out there, right? So you're like, ooh, let me go try that because this is unique. It can be inserted against an infringer. So if someone tries to use your invention, you take your patent and say, ha, ha, ha. No, you cannot. I have a patent on it, and it's still enforceable. It can be used as collateral. Like I said, it's property. And it can create revenue because people will believe and people will see that you have a patented invention, so your invention is unique. And they would want to buy into your company potentially. Who can apply? Those that invented the invention. Assignees are obligated assignees. So if somebody funded your research, funded you being able to make the invention, and you said, okay, I will give you a partial stake in this or a whole stake, and a person with sufficient proprietary interest that runs similarly along the same lines. Once you get your patent, you can license it so that others can use it and you get royalties back off that licensing. You can enforce it. You use it yourself and you use it to keep others from being able to use your invention. You can use it as a basis to be more innovative and create more competition. Or you can sell it. You don't have to keep it. Some people get patents and they decide they don't want to go into that market and they decide to sell their patented invention. I love this slide because it puts into view with one item all the different types of intellectual property that could be obtained on that item. Everybody is familiar with cell phones. While this particular example is to Apple, think broadly that it could be any type of product. So when it comes to the Apple brand, the Apple phone, the trademarks you have are the logo, the iPhone, and the software, iOS and Safari. Think about it. If you hear iOS or Safari, who are you thinking about? Apple products. Because does anybody else have a Safari search engine? No. Patents. The utility patents that are on this particular device are in the hundreds, potentially thousands. This is just some that are listed. There's patents on the semiconductor circuits. That could be the method of making the circuits, the materials that go into the circuits, how the circuits are put into the phone, the touch screen itself. Have you ever thought about what goes into a touch screen? It's not just a piece of glass. It could be a polymer. It could have multiple layers on it. The way that it's made, you have tensile compressive stresses within a glass layer itself, the properties that are used, the materials that are used. So when it comes to the touch screen, don't think, oh, we're talking about one type of patent. It's multiple. And I can go on and on. The reason there's question marks at trade secrets, because it's a trade secret. If we knew, it wouldn't be a secret, right? So when you think of your invention, your product, your service, what have you, your company, think about it outside the box. Don't just think, oh, I get this one patent. Recognize that if you have an invention, a product, it can be multiple patents on that one thing. Anything that you do for your business could be potentially copywritten if it's put in a tangible medium. Think about your branding, your trademarks, your trade dress. Think about all of it as an intellectual property portfolio that you must build for your business. And I want to say thank you so very much for your attention this morning. And as I said, I'll be available to answer questions for a little bit. I'll be around during the day. I'm also doing one-on-ones later this evening. So enjoy the rest of your day, enjoy tomorrow, and I hope you get a lot of information that you're able to go back and use to help build your brand, build your business, and be successful.